right now. I want to welcome to the program from Breitbart News, Mr. Ken Klukowski. Ken, how you doing, sir?
Cam, great to be with you. Thank you.
Absolutely. Glad you could join us. I've got a lot of emails, had a lot of tweets from folks who were a little angry about comments made by Justice Scalia over the weekend. The media obviously running with the narrative that Antonin Scalia says we can have more gun control, which is not exactly what the justice really said, right?
Yeah, not in the slightest, and I'm glad you're giving voice to this, Cam, because of course it's you and I hang out with an awful lot of gun owners.
Oh yeah.
And in the way you just had a Supreme Court justice who's just talking as a federal judge does, and then you get a media putting a spin on it. Really, I think if nothing else, either they didn't understand what the justice was saying, which is very likely, or on the off chance that they actually understood this conservative legal mind, they were deliberately trying to mess with law-abiding gun owners by freaking them out. So, and then, whichever way it is, I think you're doing a real public service, not just to NRA members, but to all gun owners by setting it straight that that's not at all what Justice Scalia was saying. This has nothing to do with gun control.
Absolutely. All right, so we've got the clip here queued up from Fox News Sunday. Let's just listen to a little portion of Justice Scalia yesterday.
Let's turn to an issue that is in the news right now with the massacre in Colorado, and that is gun control. You wrote in 2008 the opinion in District of Columbia v. Heller, the majority opinion that said the Second Amendment means what it says. People have a right to bear arms. Question, how far does that constitutional right go? Can a legislature ban semi-automatic weapons, or can it ban magazines that carry 100 rounds without violating an individual's constitutional right to bear arms?
What the opinion in Heller said is that it will have to be decided in future cases what limitations upon the right to keep and bear arms are permissible. Some undoubtedly are, because there were some that were acknowledged at the time. For example, there was a tort called affrighting, which if you carried around a really horrible weapon just to scare people, like a head axe or something, that was, I believe, a misdemeanor. So, yes, there are some limitations that can be imposed. What they are will depend on what the society understood were reasonable limitations at the time. There were certain location limitations.
Let's stop there here. So again, Ken, I mean, immediately off the bat, what struck me is that what Justice Scalia said was that Heller and McDonald didn't decide these issues. There will be future cases that will flesh out the scope of the Second Amendment. That's not controversial.
That's right, and he's saying don't walk around with a head axe, which for your audience is one of those from the movies, medieval movies. You get an executioner who's wearing the black hood over his head and is carrying one of those huge monstrous-sized axes, the only purpose for which is just to decapitate someone whose head is down there on the block. He's just saying don't walk down the sidewalk carrying one of those axes. Back in 1791, you could get in trouble for that, and that's probably true today. That's exactly right. The case in Heller, Cam, the issue was, is the Second Amendment any sort of personal right such that the federal government, in this case D.C., under federal control, cannot completely ban you from having firearms in your own home? And the answer was yes. Then in McDonald, the question was, okay, is the Second Amendment right one of those, because the Bill of Rights only applies against the federal government. Mm-hmm. The question in McDonald was, is the Second Amendment one of those rights that are also fundamental rights that are extended through the 14th Amendment to also limit the power of state and local governments on that issue? And the answer was yes. So the city of Chicago could not ban your guns. Now, I have to say, there are not 5 originalists on the Supreme Court. And Scalia, in that interview, was explaining originalism, which is that every term in the Constitution or any law, a statute or a regulation, all the words in the Constitution, a court should give to those words the meaning that a person of average intelligence and public awareness had in the year they were adopted. So in the case of the Second Amendment, it means what did that right mean in 1791, the year the Second Amendment was ratified. And in that regard, let me tell you, the Second Amendment was a broad, robust, powerful right back in the 1790s. So the First Amendment was, the Second Amendment was, with originalists like Antonin Scalia, and I have to say he's not completely consistent as originalist. I think the only consistent originalist, the one I am most in favor of in that regard, is Justice Clarence Thomas. And then Justice Sam Alito is kind of half the time an originalist. You've only got kind of 2.5 originalists on the Supreme Court. Then you start getting into other schools of thought called textualism and other stuff that are less tied to the original meaning. We do not have 5 originalist judges on the Supreme Court, which means we do not have an originalist majority on the Supreme Court. We're going to have to fight tooth and nail on some aspects of the right to keep and bear arms, and all of your listeners need to understand that this is part of what's at stake in this November's election, because remember, McDonald and Heller were both 5-4 decisions. The right to keep and bear arms by itself only survived by a single vote. We need the right judges on there, but certainly Justice Scalia is not part of the problem. He is part of the solution.
Talking with Ken Klukowski, a Breitbart legal contributor. And Ken, do you anticipate that a right to carry case is probably going to be the next Second Amendment case that the Supreme Court will hear?
I'm hoping it's a couple years. I think I'm involved myself in the legal work as we're developing the literature and laying the foundation for that. Mm-hmm. And I think we still, and by we I mean there are hundreds of lawyers involved in this, both academically and in the courtrooms. I think we need some more time in terms of laying that foundation, and I don't know how much further the current Supreme Court would go. I think they would go further than they have so far, but again, we don't have 5 reliable votes that we should feel confident on some of the issues that you and I would like to see resolved in favor of the Second Amendment. I think the next cases to be heard are going to start to explore the issue of what's called levels of scrutiny or standards of review. That's something we can maybe unpack in a future interview. You have these terms that are called strict scrutiny, intermediate scrutiny, rational basis review, and these are just the different levels as to how high of a hurdle the government needs to satisfy before it puts a burden on one of our fundamental rights. And when you get to the core exercises of the right, like for free speech, content-based restriction, saying what subjects you can and cannot talk, it's subject to a very rigorous standard called strict scrutiny. If instead you're at the other end, you're talking about what you're doing in an airport, which is not even a public forum, it is government property, but you're not there to speak and whatnot, the government has a lot more latitude there in terms of restricting what you can say in speech. I think all of those free speech principles, strict scrutiny, intermediate scrutiny, viewpoint discrimination, I think all of those can translate into a Second Amendment context, and I think that's what we're going to see in the next 10 or 20 years in the U.S. Supreme Court.
All right. Ken, thank you again, sir, for coming on the program tonight. Always a pleasure.
Thank you, Cam. Me too.
Ken Klukowski, Breitbart legal contributor, joining us here on Cam and Company.